to our next discussion around ICs under attack. I see that it's been outlawed in the state of California. Independent contractors have. What are the labor model and driver payment options available to carriers? So we're going to hear about some options here. I was speaking at a conference in Colorado earlier this week, and then one of the attorneys mentioned that Colorado is referred to California East because their employment laws are sometimes more difficult than California. So I imagine you have issues in many states, not just California. So I'm looking forward to this discussion. That's going to be moderated by Mark Kosek, President of Priority Courier Experts. So Mark, I see Mr. Feary is with us. There's Mark. I'm going to go ahead and turn it over to you.
Terrific. Can you hear me, Jennifer?
I can, yes.
Okay. Well, from this particular session, welcome to the ELS, all the participants here. I see a lot of friendly little type names out there that I recognize. Good to connect with you again. My name is Mark Kosek. I'm the President of Priority Courier Experts. We are a same-day courier and trucking company serving Minneapolis and the upper Midwest. And I'm on the board, been on the board for a while, and have concentrated in government affairs activities. I've led the Government Affairs Committee for CLDA for, might not be good when you lose count of the years, but probably about 7 years. I also serve on that in a local state trucking association. So these are issues that I pay attention to a lot. And you know, there's an old Chinese saying that says, may you be cursed to live in interesting times. And my friends, we are living in interesting times regarding the labor model that 89% of CLDA members have. 89% of CLDA members have either utilize ICs exclusively or utilize them as part of their solution. So this is a critical thing for us. Well, right about now, the DOL has published a rule. It's not made public yet. Everyone is kind of fearful of what it's going to be. And I'll talk more about what the CLDA is going to do on that. But so we're kind of getting hit from the DOL front that way. The National Labor Relations Board is also basically making some redefinitions. And I'm thinking we have to get this message out to CLDA membership. And to do that, I thought, well, who's the best person to speak at a session like that? And I immediately thought of my friend Greg Feary and Scopolitas. For those of you who don't know, Greg is the president of Scopolitas, what I consider the premier labor model company in this industry. And he's going to share with us some information about, although he may speak of what's happening in California is happening in a few other states, and the strategies he talks about for California can also be used in other states. So I'm looking forward to this presentation by Greg tremendously. When he gets done, we'll have some time for questions at the end. So Greg, if we could get the slides up there, you can take it over.
Thanks, Mark. And really, Mark has done an amazing job at the CLDA, and CLDA has done an amazing job in leading the industry. So you've got really good people I've always thought, at the top of this organization, and the organization itself is an important one that the transportation industry pays attention to. I don't blame Jennifer for reading the tagline the way she did with regard to what this presentation's about, but let me first start by saying California has not outlawed independent contractors. That has not happened. It feels that way in some regards, and certainly I'll tell you what model is in the greatest jeopardy, but independent contractor status is alive, maybe not alive and well, but alive in California. It's certainly alive in the majority of states in the country. It's a red state, blue state issue, but there are certainly battlefronts, as Mark indicated, beyond California. So let's go to the next slide. And then quickly past that, and now to the next slide. And so let's start with interesting how this California law, which is referred to as AB 5, really started. And actually, it started with a lawsuit back in before 2018 with Dynamics, a courier company. And by 2018, the California Supreme Court had this lawsuit in front of them to make a decision. Their decision was, how do we define independent contractors in the state of California? And interestingly enough, they depart from what is referred to in law as stare decisis or precedent, and import a brand new way of looking at independent contractors. And not only do they import it and say, okay, this is the law, they say this has always been the law, which was an interesting take on how things are actually supposed to be done in the law. So we have the Dynamics case that effectively brings in, next slide, please, the ABC test. You can read this ABC test for yourself. I can be quick about it. Prong A is right of control. Anybody that knows this area knows that that is a factor in virtually every law used to determine independent contractor status. We can drop down to prong C and say not a foreign prong at all. You can, it's often that you see this particular part of the factors used to determine independent contractor status. And I would go so far as to say, even the B prong, right in the middle, the hardest one, the biggest challenge, worker performs work that's outside the usual course of the hiring entity's business. There's another way to look at that. Is the worker that we're saying is an independent contractor in the same trade, profession, or occupation as you, the courier company? All right, so even that prong you see in various laws across the country, usually in an unemployment tax. Here's what an ABC test does that's more unusual than just these three factors. It is, if you don't prove, and you're the one that has to prove it, the courier company has to prove it. If one of the workers says, well, I'm an employee, not an independent contractor, you have to walk in and prove each one of these three prongs. If you miss one, if you can't prove one, then that worker is an employee. Next slide, please. What happens next? Well, the legislature stepped in, took the Dynamics case. The particular assemblywoman was a woman by the name of Lorena Gonzalez, who wrote it up into a bill and then expanded it. Give you a little perspective on Assemblywoman Gonzalez. She, before being voted into the legislature, she was the secretary of the California AFL-CIO. And now she is back in the private sector or the labor union sector. She's now with the California Labor Federation. So her allegiances have always been with organized labor and unions. In September of 2020, the bill was passed effective January 1st, 2020. And then by September 2020, it had been amended a little bit to recast or clarify some of the provisions of the bill by a bill called AB 2257. It's still referred to as AB5. Next slide, please. What happened next? Well, quickly, the California Trucking Association filed a lawsuit contesting the enforcement of this law to interstate transportation. And that went all the way down to the courier industry, not just heavy trucking, interstate. I'll say interstate trucking, but it includes the courier industry. And to quickly get to the punchline, while the federal district court agreed with the California Trucking Association and said this law should be preempted because only the federal law can pass a law that affects prices, routes, or services of transportation, the Ninth Circuit had disagreed. It was then appealed to the U.S. Supreme Court, and June 30th of this year, the Supreme Court denied hearing the case. Therefore, the law is, as of August 29th, was turned back on. The injunction was lifted, and we expect activity by both the prosecutors of the various agencies The DLSE is the prosecutorial or enforcement arm of the California Department of Labor. We expect a lot of activity from them, from the California EDD. Many courier companies know of the California EDD, that's the Unemployment Tax Agency. And certainly many of the class action lawsuits that were put on hold during this period from 2019 up until recently, they're turned back on and they're active and moving forward. Next slide, please. So the law did a couple of things. It certainly applied the ABC test to all businesses, all industries in California, followed by exempting out many, many industries and businesses in California. But it left very much intact the application of the law to the transportation industry. In fact, Lorena Gonzalez was very clear in public addresses that she was targeting not only trucking, but Uber, Lyft, DoorDash, all of those businesses, and including, because this whole issue arises out of courier deliveries, she was targeting our industry. So there was no exemption for our industry, and I don't hold out any hope for there to be. But there is a business-to-business exemption. Next slide, please. So the business-to-business exemption is, in effect, a way to look at what a business actually would be. And I think it was an attempt, or at least a superficial or cosmetic attempt, to say, well, we really don't want actual businesses not in their relationship with other businesses not to be independent contractor relationships. We don't want those to be employees. So what they do is they enact the business-to-business exemption. Next slide. Here are the elements of the business-to-business exemption. You can disregard, for the most part, element 12, simply because that really applies to the construction industry. And then when you look at all the 11 elements, if you're in court saying, wait a minute, the ABC test doesn't apply to us because we're doing business with another business, you then have to prove all 11 of these factors. And just make a mental note, factor 1 is the A prong of the ABC test, and factor 6 is the C prong of the ABC test. You don't see a factor in here that mirrors the B prong. Let's move to the next slide, please. But let's look at some of the most troubling factors, the 2, 4, 7, and 8. And I'm not going to go into infinite detail about those, but those we see as being real challenges to being able to prove, and you have to prove all 11 factors. You're likely to run up against some real high hurdles to prove one or more of these 4 specific factors or elements. Next slide, please. So what happens if you do, if you're lucky and you prove all 11? You're trying to exit the ABC test. You're trying to get into the Borello test. Next slide. This is the Borello test. Well, what's the good news about the Borello test is it is a multi-factor balancing test. It's not like the ABC test where you have to prove every one of the 3 factors in a multi-factor balancing test, which you have predominantly throughout the country, in not only at the federal level but at the state level. You're trying to prove the majority of these items, and if you prove the majority of these items, you're demonstrating that the worker is an independent contractor. But let's be clear: when you prove the business-to-business exemption, all you're doing is putting yourself into another test, and once again, you have to prove that test. And you can imagine how expensive. Many of you don't have to imagine; you probably know how expensive that is from a legal perspective to do in court. Next slide, please. So what are the options for carriers operating in California? Mark made a good point. These options are options that are, I guess I would say, available today, depending on your perspective and where you're doing business. And whether you feel like the independent contractor model is in jeopardy or moving towards being in similar jeopardy as it has been placed in California. So these are not exclusive to California. These are general options. Next slide, please. So I'm going to go through all of them, but fairly quickly. This is just a laundry list. We actually have 11 options, 8 of which are identified on these slides. The remaining 3 are just variations of the 8 primary. Next slide, please. And these are the rest of them. So let's talk about the options in a little more detail. Next slide, please. What is the strategic dispatch? Honestly, I think the courier industry would have a hard time in most regards on strategic dispatch because most of courier deliveries occur in a fairly small radius area. With regard to California, many of them, if not the great majority of them, never cross state lines. But the strategic dispatch, in short, would be picking contractors that have a more compelling work nexus in another state, such that we can argue that the California law just simply has no jurisdiction over them. Next slide. And the jurisdictional issue for California is a combination of pickup and delivery and how much time is being spent in the state of California. I know there are a number of couriers that do have some long haul, heavier trucking as part of their operations. So in brief, I could say if you had a number of contractors that, for example, reside and are domiciled in the state of Nevada, and most of their work is in Nevada, but every once in a while they cross state lines and pick up loads in California and deliver them elsewhere, or even in California. But you're convinced that the predominant amount of time of their delivery is spent in Nevada. Most of their pickup and delivery are in Nevada or other states. Then you can walk into court and say AB5 just simply doesn't have jurisdictional reach to my contractors. Next slide. The California compensation addendum effectively is intended to take away the damages. It just says, okay, we're going to pay our contractors in a very different way, and we're going to change the addendum to our independent contractor agreement to effectively say, well, fine, you can call my contractor an employee, but in the end, I do pay for non-driving activities. I do pay for rest breaks, and I do identify expense reimbursements and compensation and pay them. These are ideas that would reduce you as a big target into a smaller target for plaintiffs' attorneys. I can't say that it would necessarily dissuade state prosecutors. Next slide. B2B compliance. You could look at some of these efforts. Again, I think, though, that with regard to B2B compliance, there are some serious elements that you would have a hard time getting past. And again, then you're just back into the Borello test. Next slide. Fleet operators with employee drivers, often referred to in the courier industry as master contractors. You know, back when this law was about to take effect in 2019, I had many clients say, I can't just have master contractors treat their delivery drivers as employees. In order to do that, I would have to get fairly significant price increases from my customers. And I don't know that I have any master contractors that really want to do business with their delivery drivers as if they're employees. I think they want to be sub-independent contractors. And I understood that, and I got that perspective in the vast majority of my interactions with clients. Here we are with the law turned back on, and I've got a lot of clients saying, no, they think they can do it now. This is often referred to as the FedEx model. FedEx pivoted to this model back in 2010 after a fairly large lawsuit by the name of Estrada versus FedEx. And so it is it does have some potential for resolving the problem, but it's basically pushing the problem down to the master contractor, who then has to comply with the employment laws by treating those drivers as employees. Next slide, please. Question on joint employment. If let's say you maintain your operations in California, and the contractor then has many of his own independent contractors. Well, under a joint employment analysis, AB5 doesn't apply. AB5 only applies in a direct employment analysis. So if you could argue, well, wait a minute, I actually tender my deliveries to a contractor, and then he turns around and tenders those to a number of delivery drivers that he considers contractors. At worst, I should be considered a joint employer, not a direct employer, and AB5 shouldn't apply to me at all. Well, the way the law is developed so far in California, that joint employment argument has not actually gotten much traction unless the contractor that you're doing business with has acknowledged and treated those delivery drivers as employees. In other words, issued W-2s to them and in all regards treated them as employees. We'll see how the law develops in this regard. Next slide. Settlement carrier model. The settlement carrier model is a little bit of an unusual animal, again, in the courier industry, because once again, at least in California, most of your operations might be considered intrastate. Now, a lot of operations are interstate in nature because of what you're delivering. And Mark and I have been on daises before and talked about this before. Just because your vehicles don't cross state lines doesn't mean the delivery isn't interstate or regulated under federal law. It really depends either on crossing state lines or whether the goods that are being delivered are a continuation of an out-of-state move. You could therefore go get brokerage authority, which is available at the federal level, but not available in California at the state level. There's actually only 3 states that recognize at the state level brokerage authority. That would be Washington, Alabama, and Illinois. If you got federal brokerage authority and what's referred to as voluntarily revoked your motor carrier authority, you could tender the freight to these contractors and they would have to get their own motor carrier authority. The argument then would be, well, under the B-prong analysis, I'm in one trade, occupation, or profession, and they're in a different one. I'm a broker, they're a motor carrier. The laws that govern and determine who we are very different. There's an Indiana Supreme Court case that runs along those lines and finds that the transportation company was not an employer and the relationship was an independent contractor. So there is at least one important case that supports that concept. Next slide, please. Proposition 22, a lot of courier companies are very interested in Proposition 22. If you know what that is, you know that Uber, Lyft, and DoorDash put an enormous amount of money together to get a referendum on the 2020 ballot. The citizens of California voted 58% in favor of Proposition 22. And what Proposition 22 basically said was delivery using personal or passenger vehicles on an app-based platform within a 50-mile radius of pickup and delivery with no more than 12 distinct orders, not 12 packages, but 12 sources of packages, and with certain benefits and minimum wages extended to the delivery drivers, would not be subject to AB5. I have found that the 50-mile delivery radius has been a bit of a problem for a lot of couriers, and the no more than 12 distinct orders could be as well. You would have to do your own examination of whether you fit within the Proposition 22 model, but it could be a way in which to preserve what you're doing in the state of California. And by the way, since we're talking about, hey, this could this could go past California into other states. I'm going to tell you shortly that the state of Washington is likely the next place where you'll see an AB5 type law. You can expect Uber, Lyft, and DoorDash to be there with another referendum. They did that in New Jersey. New Jersey has not passed, by the way, an AB5 law. It was Senate Bill 863. They've attempted to pass it for 2 legislative sessions and have gotten no real traction to do so. So my point is that if you see this law proliferating around the country, you're also going to see at least a strong effort by the gig economy to have a Proposition 22 solution proliferate, and it will look a lot like this one. Next slide. This one seems easy, and it's kind of a duh moment. Hey, if what California is saying is we want all the workers to be employees, then why don't we just do that? Let's just stop the brain damage. We'll just have all our workers be employees. Well, that sounds good. And in certain segments, maybe it is. I don't know. But my experience in 35 years of practicing law and listening to thousands of clients talk is that these drivers don't want to be employees. They want to be independent contractors. So simply telling them that they're going to be employees is only half of the equation. The other half of the equation is them agreeing that that's what they'll do. And instead of agreeing to doing it, they may agree to just leave and do something else, get out of the delivery business, or go to somebody that actually will allow them to have their own business and conduct themselves in an entrepreneurial manner. The next slide, please. So that brings you to a variation of let's just make them employees, which is called the 2-check system. Under the 2-check system, you pay them in the courier industry, I would say 40% of what you did pay them and call it wages, issue W-2, and the remaining 60% would be the rental of their vehicle. There is a small problem, and it could be a large problem. That rental that you're providing to them honestly could be considered by the IRS to be yet another payroll check. And they ask 2 questions to determine that, whether anybody else could use that rented vehicle other than who you've rented it from, and whether if that driver were to leave your employment, could they take the vehicle with them, or would they have to wait until the end of the rental period to do that? Often the answers to those 2 questions are no, they can't drive. Nobody else can drive that vehicle, and when they leave, they take their vehicle with them. So there is a bit of a problem with the 2-check system. That being said, the IRS has not been consistent in the way they've enforced their assessments based on the 2-check system. Certainly in the Southwest, Texas in particular, the IRS has not seemed to have a problem with the 2-check system. Next slide. What are the other states that we expect to see some problems? Well, again, I started this by saying the issue of independent contractor status has always been not just a mixed question of fact and law, but also a mixed question of law and politics. From a political perspective, states that have a paternal perspective or lean paternally tend to lean left, tend to lean blue. Those blue states want to see all workers protected, and in fact feel like all workers need to be protected from their own judgment and their own decisions. In that regard, you'll see that when you think about blue states, and Jennifer kind of tipped this off in her opening comments, states like Colorado, yeah, I wouldn't be surprised to see that as a problematic state. It is a problematic state. Washington, Oregon, New York, New Jersey, Connecticut, Illinois. These are states where I would expect you're going to have problems that could manifest in an AB5 law that applies across the board. There, in fact, certain of these states already have ABC tests. They just don't have them in high-profile areas of the law, like wage and hour. Next slide. So Mark asked me to kind of, and he tipped his hand a little bit too, talk about, next slide, please, the federal level. And let's, next slide. And not to put a real pretty face on this, but the last 12 months could have been worse. Let's go to the next slide. There is at least 3 silver linings. Number one, the ABC test did find its way into the PRO Act, but the PRO Act is subject to the filibuster rule in the Senate. And until there's 60 senators willing to vote for the PRO Act, we're not going to see an ABC test in the NLRA. David Weil was the Obama era chief of the wage and hour division of the US DOL. They put him up for nomination to put him back in that position. His nomination did not go through. That was more good news. The current nominee that likely will go through is Jessica Lumen. She has already said that she doesn't think that the Department of Labor can simply adopt a rule through rulemaking and regulation that would include an ABC test. She has publicly stated Congress would have to enact an ABC test. It's significant enough change that it can't be simply interpreted as rulemaking. Next slide. So that's all the good news we've got. Let's now go to the Department of Labor a little bit. Mark's already said that. I'll go to the punchline. As of September 28th, just here recently, the OMB cleared that rule. That rule should be coming out momentarily. I haven't looked today. It could have come out today. I don't think it has, or I would be noticed that it had. But the Department of Labor is going to have a rule that's going to lean left. Let's be clear about that. It's going to have an interpretation that will favor paternalism, and it will favor the finding of employment status. Next slide. The NLRB. Well, the NLRB, next slide, please. The NLRB is the most famously politically influenced agency in federal government. And currently, it's a 5-member board, 3 of which are Democrats, and it's as well as its chief attorney. And next slide, please. We're not going to get a fair shake there. We're going to have a rule that again is going to favor employment status. Next slide. And the joint employer rule that was just rescinded is going to be replaced by a new joint employer rule. The Trump era a joint employer rule was, and this is very relevant to you who use master contractors. The question under the Trump rule was not just that you reserve the right to control the ultimate delivery driver, but you've exercised that right. So Trump said, no, just because your contract says you have some rights, unless the plaintiff's attorney can come into court and show that you've actually exercised those rights, you're not going to be labeled a joint employer. The new rule says, no, it's just good enough that you've reserved certain rights in your contract. And that would be enough to paint you as a joint employer. Next slide. So here's the most interesting one. When I saw it, I scratched my head. The NLRB has a memorandum of understanding with the DOJ. Now that's not unusual, but also the FTC. Well, the FTC is in charge with the Department of Justice, is in charge of antitrust violations. So how are we getting the NLRB to get the 2 agencies that deal with antitrust violations to focus their attention on an independent contractor issue. Here's how it works. There is a word that maybe is not, unless you're an economics major, might be a foreign word to you. It's called monopsony. A monopsony is best described, I guess the common description would be, if I work in a small coal town and the coal company is the only employer, then the coal company basically has cornered the labor market. They have a monopsony, and they can determine exactly what the labor market looks like, how much wages are being paid and what kind of benefits. And so they coined that phrase monopsony, and then they've expanded that not to just, for example, one employer in a limited geographical area. You could argue that professional sports are monopsonies. And you might argue, and this is interesting as a comment that Mark made at the very beginning, and it's set up perfectly for this last slide. You might argue that the courier industry is a monopsony in the sense that it is so predominantly using independent contractors that maybe the FTC and DOJ would say they can't go anywhere else and get a job that isn't an independent contractor job. You've got a couple of segments where that's true. Maybe couriers. Honestly, I think that's a heavy lift. Maybe home delivery and maybe port drayage. Those are the three segments that are most significantly and nearly exclusively independent contractor model transportation platforms. So you could actually see the FTC and the DOJ get into this act and start yet, fourth, you've got the IRS, the DOL, the FTC, the DOJ, the NLRB, all putting pressure on this independent contractor model. So yes, we're concerned, and to run full circle back to the beginning of the presentation, Jennifer said, within the context of introducing the topic, that independent contractors were outlawed in California. And I said, well, they're not. But maybe her comment was more accurate than mine in that the amount of enormous pressure on the model is such that you would feel as though it was nearly outlawed. And with that, Mark, I know I went through all of this quickly because I predicted that we might have quite a few questions. So I'll turn it back over to you.
Thank you, Greg. And there will be time for just a few questions. I did want to tell everybody what the CLDA is doing in regards to both of these things. We are part of multiple coalitions that as soon as the DOL comments appear or the DOL proposal appears, we are going to be taking that. We are going to be drafting comments which we think are appropriate for our industry. We're going to be submitting comments independently and directly to the Department of Labor, which will have the concerns of our members in mind and will also be formed by talking to our other coalition partners. Okay? So we believe we'll have a very well-informed set of comments because, of course, concerned industries, concerned businesses submit all their comments back into the DOL, then it goes into the meat grinder again, and then they come out with the final rule. Now, we're not going to completely turn it on its head. We're not going to stop it. We're not going to turn what is going to be a left-leaning rule into a right-leaning rule. But what we're going to try to do is take the edges off wherever we can. And if there are any killer items in there, we're going to attack those as hard as we can. As Greg said, is it illegal to run ICs in California? No. But when you look at all the things, the hoops you have to jump through, practically speaking, it's just really difficult. So you really better have your I's dotted and your T's crossed. You better have worked with someone like Greg or some of the fine third parties we have in this in our industry here. We've got Open Forest and SCI, and we've got Greg's firm. And by the way, those are all three strategic partners of the CLDA, and they deserve help. They do help this industry a lot. And I was talking recently to the vice president of the ATA on workforce development, and we were talking through what's going to come out of the DOL, and he also believes it's going to be difficult So he's not looking forward to that. He said, but Mark, what really scares me is what's going to come out of the NLRB. He says that's going to scare him even worse than what's coming out of the DOL. Because the way it works with the NLRB is, of course, the NLRB was set up in place to handle, union elections and to ensure that they're fair and easily administered. So the normal course of events is a union will come up and say that we want to unionize the people in your shop. And they'll say, well, wait, we're independent contractors. Well, no, we want to hold a union election. So then they say, well, wait a second, what government entity covers that? That's the NLRB, okay? That's why the criteria that the NLRB has for independent contractors is so critical. And as Greg said, this is an agency that flops back and forth, left and right, depending on who's in charge. That's why to some extent, whoever's the president determines whether we're going to have a lot of headaches or not. Congress can flip back and forth, and it's hard to get things through Congress. But if you can't get things through Congress, guess where you're going to go? You're going to go to the federal agencies, and that's where you're going to attack. So the CLDA's Government Affairs Committee, we're going to be working very hard to get highly meaningful and impactful comments into the DOL, and to follow up with any case laws or amicus briefs that we can on appropriate lawsuits. So that's what we're going to do as an association. Greg got out the good, all the great content, and he is someone to go to if you need it. Now, if there are questions, let's see, Melanie, do the questions come in through the chat, or will they just speak right up? Jennifer?
If someone does have a question, they could type it in the chat. We have about 2 minutes to get you a great answer.
So an easy question, please.
You've stunned everyone.
Yeah, well, either that or they're so familiar with this issue and they're so beleaguered by it that no questions are needed.
Well, I tried to set you up by saying it was illegal in California. So.
No, I know, that was great.
See if people would wake up, but actually I did.
But let me say one more thing then. Again, if you're in a state that's having these types of difficulties, download the slides that Greg put out there. Look at some of those alternate business models where, it may not be the traditional way to run an IC shop, but it might be one of the only ways to do so in the state that you may be in.
Yeah.
Take a look at those and then get good legal counsel.
Okay, do you want to sum it up, either Greg or Mark? Would leave us with some words of good news?
I'll leave a minute for Mark. My summary would be, you just have to really stay informed on this subject because it's nuanced. You have a lot of plaintiffs' attorneys that are trying to get rich on this, and that's been the case for quite a long time. And now the states, especially in a recession, are looking for tax revenue, and they're going to be fired up. So the best protection is to be knowledgeable and informed. And Mark, I'll let you close it down.
Thank you. I guess the only good news I would have here is there is an election coming up. Quite frankly, get out, vote, and encourage your drivers to get out and vote. If the Senate and the House flips, we can have Senate members and House members putting pressure on these federal agencies to not overstep their bounds. Get out and vote to help your local state initiatives. And if you want to start building relationships with local politicians at the local level to help you, you're going to be a champion of this industry. The way to influence and protect your business is to create relationships, create them at the state level, and then we work at the federal level, because candidates go from the state to the federal level. So getting involved is the way to fix this stuff, folks. It really is. It affects your business, affects your livelihood, affects your family. Don't give up. We may be an undersized industry, but company for company and person for person, I think we fight harder and present a better case. When we're sitting in front of a senator or a congressman or woman, we can tell a very good story, and it's helped in the past, and we'll do it again. Thanks, Jennifer.